congratulate you from Nevada for getting to participate in the We the People National Challenge. It's a real accomplishment any year, but it's especially an accomplishment this year in light of the difficulties that all of us have experienced with the coronavirus. I notice on the screen that there are a lot of people who are listening in, and we're glad that you have other people who are supporting you in this during this hearing. My name is Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado, and my colleagues will introduce themselves to you as well.
Thank you. I'm Dave Adler. I'm president of the Alturas Institute and adjunct faculty member at the law school at University of Idaho. It's a pleasure to be with you. I always enjoy judging at the national finals and have always been impressed with the caliber of students. And you should feel very proud of your achievement today, having overcome adverse circumstances to make it to We the People national finals challenges. So I look forward to our conversation today.
Thank you, Kayla and colleagues. I'm Donald Rogers. I teach history at Central Connecticut State University. I've been working with the We the People program for many years. I know it's very competitive. It's an excellent program, and I know it's a real achievement for you to reach the national final. So I congratulate you and say I really look forward to hearing to what you have to say about our question.
Now we'd like you all to introduce yourselves and tell us about one thing that you were doing before the coronavirus pandemic started. And also, if one of you could introduce your teacher, we would appreciate that as well.
Good afternoon. We're Reno High School's Unit 4. I'm Madison Schultz and will be attending the University of Nevada. And one thing I was doing before was running track.
I'm Jason Montgomery. I will be attending Montana State University, and I was lucky to finish on my Eagle Scout before all of this coronavirus happened.
My name is Cendrina Duhamel. I will be attending the University of Nevada, and I was playing lacrosse previous to the corona pandemic.
I'm Nathan Hunsberger. I'll be attending Vanderbilt University, and before the coronavirus pandemic, I was playing baseball.
I'm Marlo Towle. I'll be attending the University of Utah, and our teacher and unit coach is Mr. Richard Clark. And before the coronavirus, I was playing lacrosse for the first time.
Thank you for sharing the introductions and your personal information. We appreciate learning a little bit about you. I'm now going to read the question, and then we'll hear your opening statement and then ask you some questions. Article 1, Section 4 of the Constitution provides that state legislatures can determine the time, places, and manner of holding elections for senators and representatives. It gives Congress the power to make or alter such regulations. What are the advantages and disadvantages of a uniform election process? What responsibility do state legislatures, state election officials, and citizens have in maintaining free and fair elections? What are the advantages and disadvantages of the trustee and delegate theories of representation as they apply to congressional districts? You may begin.
A citizen, a qualified voter, is no more nor no less an essential part of the concept of a government of laws. This is at the heart of Lincoln's vision of government, of the people, by the people, and for the people. Justice Douglas's opinion in Reynolds versus Sims demonstrates the necessity for a uniform election process. The protection of the right to vote is thus an integral function of both layers of our federalist system.
In order to support President Lincoln's view of government, voting must adhere to its democratic standards.
Of the people. Our system of democracy is designed to easily allow citizens to integrate themselves and represent their values in government.
By the people, it is the role of these citizens to participate in order to establish a government which defends its constituents' ideals.
For the people, our government must preserve suffrage in every state.
As James Madison warned at the Philadelphia Convention, states can mold their regulations as to favor the candidates they wish to succeed. Prior to the 2018 Georgia election, 1.4 million voters were purged over a 6-year period, largely targeting voters of color. This laboratory of oppression could have been avoided with a uniform election process that allowed Congress to step in to create a national voter registration system.
Congress has attempted to solve these problems facing democracy. The Voting Rights Act of 1965 used the 15th Amendment's enforcement provisions to establish uniform election regulations to prohibit voting practices that discriminate on the basis of race to protect voting for the people.
In 2002, Congress indirectly created a uniform election process through the Help America Vote Act, which gave states $3 billion to help reform their voting methods and establish a national standard to provide better voting security for the people.
However, the disadvantage of a uniform election system is the thwarting of laboratories of democracies within states. In Nevada, we use electronic voting system with a paper trail, as well as providing early voting. In 2018, 56% of the active electorate voted early, creating more ease and reliability in the voting process.
State election officials uphold the integrity of elections by ensuring that each is conducted in a fair and unbiased manner. In 2018, North Carolina's State Board of Elections refused to certify results after allegations of voter fraud, causing the board to call a special election to uphold the ideal of free and fair elections, demonstrating the measures that state officials take to ensure that every vote by the people is secured.
Citizens have the responsibility of being civically educated in order to maintain free and fair elections. A full year of civic education is only required by 9 states. Looking to fix this issue, the 2018 case Cook versus Raimondo argued that Rhode Island is not providing an education that adequately prepares students to participate as informed citizens in civic life. If our governments aren't taking the steps to properly educate our citizens, it is the duty of the people to take up this responsibility.
To ensure that our government system is of the people, representation must reflect the needs of the residents in the area. The trustee model allows representatives to make decisions based on what they feel is best for their constituents. As epitomized by former Representative Eric Massa of New York, I will vote adamantly against the interests of my district if I think what I'm doing is going to be helpful. The advantages of this system are that elected representatives may be better educated than the general public and therefore more able to make positive and organized decisions.
Yet, the disadvantages of the trustee theory are that representatives can use power for their own means, moving away from an ideal democracy. This is contrasted by the delegate model, in which representatives are dependent on the will of the people. While this presents the advantage of being closer to the ideal of a representative democracy, it poses the disadvantage that naive policy choices may result from an uninformed electorate. Nevada lawmaker Jim Wheeler told Republicans that he would vote to allow slavery if that is what his constituents wanted.
In order to truly be a representative democracy, voting must be a priority of all levels of government. Supporting President Lincoln's initial view, voting preservation allows the government to be of the people, by the people, and for the people. Thank you.
Thank you. I'd like to start by asking you if you're familiar with the case of Shelby County v. Holder, and if so, what the Supreme Court held in that case and its effect on voting throughout the United States.
Well,
Go ahead.
Marlo, go for it.
The Supreme Court held in Shelby County versus Holder that sections 4 and 5B of the Voting Rights Act of 1965 were no longer applicable and did not need to be applied to states any longer. And this means that states do not have to run by their changes in their election law by the federal government anymore, and they can change them without approval from Congress.
It runs parallel to the Compromise of 1877, which ended the era of Reconstruction, allowing Southern states to begin implementing Jim Crow era legislation such as poll taxes, literacy tests, and grandfather clauses. Similarly, the Shelby County versus Holder decision has allowed this pretextual second generation voting barriers such as Senate Bill 5 in Texas, which implements a photo ID requirement.
The court also used a previous case, Northwestern Austin Utilities Municipal versus Holder, where in that case they deemed that current voting burdens must be justified by current needs, and they said that the Voting Rights Act was a departure from the principle of dual sovereignty, and so they felt that it was no longer suitable.
Thank you. When you think about the impact of state laws and regulations on the franchise availability to American citizens, do you believe at this point in time that there are still some groups in America that are disenfranchised or might become disenfranchised by virtue of the COVID virus? in November?
Yes, there are a lot of groups that are disenfranchised, for example, felons, but specifically in Nevada, there's an assembly bill called 431, which protects voting felon rights, which is an example of a state moving away from the disenfranchisement of groups that are franchised in other states.
In Nevada, Native Americans actually have a lot of time trying to get to polling places and are not provided many polling places, specifically in Washoe County. Recently, they filed against the Secretary of State in order to gain more polling places and more voting access for the tribes in Washoe.
Similarly, after the Shelby County versus Holder decision, many states have implemented photo ID requirements, and the Brennan Center for Civic Justice found that in Texas, Senate Bill 14, which was one of the strictest photo ID legislation requirements of its time, disenfranchised 600,000 registered voters as they were low income and did not have photo ID available.
With the rise of coronavirus, it has been shown that people who may be older or have respiratory diseases are harder impacted by this. And so they may fear going out to local polling places. And so they may be disenfranchised, as in Wisconsin, where people could not get absentee ballots quick enough in time for their primary.
You mentioned Jim Crow laws. And I'm wondering if you see Jim Crow laws as a violation of the state's responsibility to create free and fair elections. And if so, what, if anything, did Congress do about it? What should Congress do about it?
Well, Congress has its 141 power to ensure that voting throughout the states is fair, and they can make any regulations to change it. But I do think that there are some Jim Crow laws that are still highly prevalent, specifically among poorer, less educated voters. In California, about half of their Mexican electorate does not have voter ID, and so they are completely disenfranchised from voting. And a way to change this would be to go to state legislatures and propose initiatives and/or referendums to help change the law.
Modern Jim Crow can also be seen through redlining, where cities and states are drawn out to disenfranchise certain inhibitants, whether it's through poll places, etc. And Congress could enact a uniform redistricting program, such as the one Iowa pioneered, which has 5 requirements that allow for nonpartisan redistricting.
Similarly, Congress could invoke Article 4, Section 4's guarantee a Republican form of government, as Jim Crow legislation disenfranchises a certain group, which goes against everything James Madison argued in Federalist 43, which said that a Republican form of government derives its power from the consent of all people, not just certain individuals who hold power.
In addition to the statutes that you mentioned, the Voting Rights Act and the Help America Vote Act, to what extent do you think constitutional amendments in the area of voting have helped to ensure that we have free and fair elections?
Well, the 15th Amendment provided for the Voting Rights Act of 1965 through its enforcement provision, and this has tremendously helped voting rights and providing for free and fair elections, because states and the federal government cannot discriminate on the basis of race to prevent voting, which furthers enfranchisement for more people.
The 26th Amendment will allow me and all of my colleagues to vote in this upcoming election. And the enforcement provisions of also the 19th, 24th, and 26th Amendment have allowed Congress to expand protections. May I continue? That was time.
Yeah. Is it time?
Yeah. May I continue
okay.
my answer?
I think we're out of time, so thank you.
Thank you.
Thank you very much for your presentation. It went by all too quickly. You were clearly very knowledgeable and about all parts of the question that you were asked to address. I appreciate your detailed reference to Abraham Lincoln and his notion of the people, by the people, and for the people as a way to establish government, and tying that into the question about uniformity of elections or having state experimentation with elections. I like that you talked about the role of citizens in terms of ensuring that there were free and fair elections. you might have mentioned the We the People program as a way of ensuring that students are educated. Although I should add parenthetically that we haven't heard any team mention the We the People as ensuring that we have an educated electorate. I was very impressed with your answer to my question about the Shelby County case, because not only were you familiar with the case, but you showed a detailed familiarity with it and how it has had an impact and cited specific examples. And then at the end, when you were talking about amendments, you listed a whole slew of constitutional amendments that deal with voting, and all of those answers showed a real in-depth knowledge of the questions that we have asked you about today. And so I commend you on your presentation this afternoon.
Thank you.
I agree with Judge Taubman's assessment. I thought your performance was very, very strong. I was impressed from the opening and your interest in and your creative presentation of Lincoln to weave in and out. And I really admired the establishment of your platform in that way. We've not seen any other team do that, and that was very refreshing and, as I say, very strong. In response to my question about disenfranchisement, I think you exhibited a great deal of depth of knowledge and breadth. Not only did you immediately turn to the plight of Native Americans in Nevada, but you were able to cite the problems in other states, including Florida and other states dealing with the problem of restoration of felons. You cited the very onerous, repressive Texas voter ID law. And you alluded to the problems that the elderly would face if, in fact, the COVID virus interferes with the November election. I liked all of that very much. You showed a real sophistication and maturity in applying constitutional principles, case law, and historical knowledge to the questions that we posed to you. So I want to say, job well done. This was truly enjoyable, and I want to wish you the best of luck going forward.
Thank you.
I agree with Judge Taubman and Professor Adler. It was a very good presentation, very, very well organized. I very much liked the opening with Abraham Lincoln and his vision of electoral democracy. I thought that set a very good tone for you to organize your presentation. I thought you hit each part of the question very effectively with arguments and with evidence. On the Jim Crow issue, I thought that was an opening you could have exploited a little bit more to sort of drill down a little bit in exactly what Jim Crow laws involved. These are race-based procedures that deny African Americans the right to vote, which don't mention race. I mean, the literacy test, for example. And you could have mentioned the case of Williams versus Mississippi. The Supreme Court upheld that procedure. So you could have drilled down a little bit more and then go on to talk about what was done about that, especially the poll tax amendment, 24th Amendment, and the Voting Rights Act. So you could have said more there, but I really like the fact that you brought up evidence from California and elsewhere that race-based discrimination in the voting system is not something of the past, unfortunately. And so that calls for maybe some attention for Congress to intervene. So very knowledgeable presentation, and I enjoyed it and learned from it. I appreciate it. Thank you.
Thank you.
Thank you again to all of you for your excellent presentation. Let's show our appreciation to the students, their teacher, and other people who supported the students. Thank you again. That concludes our, not only your presentation, but the We the People hearings for the weekend. So thank you.